everyone. I'm Keri Sicard, owner of Virtual IP Law. I am a registered patent attorney, and I have to tell you guys this is not legal advice. This is only for information. This is being recorded, and we will have questions and answers at the end. If you could hold them until then, or put them in the chat if you're on Zoom, and we'll address them at the end. Just a little overview of what I'm going to talk about. I'm going to talk about what is intellectual property, some tips to ensure your freedom to operate your business or to roll out your products, and also ways to protect your business, secure your space, and grow your assets. What is a patent attorney? Patent attorney is just like any other attorney, but they also have a technical degree. I have a Bachelor of Science in Electrical and Computer Engineering, so that when I work with engineers at different companies, I can interface with them and I kind of know what they're talking about for the most part. So it's basically a nerd that went on to law school. There's a separate examination that you have to take to be admitted to the patent office. So the bar is pretty high, no pun intended. What is intellectual property? So there is a lot to it. I'm going to focus on copyrights, trademarks, and patents. Copyrights protect works of art, books, movies, songs, things like that. You have rights as soon as you create it. It only protects exact copies. Trademarks are your source identifier for your goods or your services. It protects copies and anything that's confusingly similar. Your trademark rights exist when you use the mark. So trademarks, you can use a trademark forever and retain your rights to that trademark. However, the inverse, when you stop using it, you stop having rights to the trademarks. Patents cover an article, machine, or process. They protect what is claimed. Your claims are kind of like your metes and bounds in a deed. It tells you exactly what the patent is claiming. So an example I like to use is John Deere tractors. They may have a copyright on their owner's manual so that no one can exactly copy it. The name John Deere has a trademark, and if they come up with any new equipment, that would be a machine covered under patents. Patent rights only exist when you file a patent, and if you disclose your idea before you file a patent, you could lose your rights to it. So just to give you an idea for how valuable trademarks can be, these are the top 10 most valuable trademarks. No surprise, Amazon is on top. It's just, and most of these come, well, a lot of them have innovative patent ideas as well, but some of them are just protecting the literal land. There are many different types of trademarks. There are word marks, which cover just names. There are stylized marks that cover logos. Service marks are basically just a trademark that's tied to services instead of a good. There are also sound marks, such as the ESPN, the end of that, those are great to buy. Yes. And there are color marks. Here are some examples. And I do have to say, I did not create this picture. I pulled it from this website, IP Watchdog. And so John Deere Green, here's another, I love this example. They also have a color mark on John Deere Green. Tiffany Blue, UPS Brown. Yeah, it didn't quite come up like brown. So when choosing a business name or a product name, there are some things to think about. The first and foremost that a lot of people forget about, a lot of businesses forget about, is making sure that no one else is using your name. Your name also cannot be descriptive. An example I like is Apple Live Photos. So if anyone has an iPhone, they have live photos. They tried to register that trademark. It got through and was published. Every trademark is published for opposition, but you only have 30 days to oppose it. Anybody can oppose it. So it actually went through the trademark office and a third party opposed it and said, live photos is too descriptive of what they are, and they were able to kill that trademark. It also can't falsely suggest a connection to someone. Just 2 days ago, a company tried using the word NATO for tents, and they were rejected for being falsely suggesting a connection to NATO. They also can't be confusingly similar to someone else. So this is actually before the courts right now. Home Chef is what's called a senior mark. And Grubhub came along and thought that they could just start using it. I think they're probably gonna lose, but we'll see what the courts say.
You think Grubhub's going to?
I do, I think it's too similar. And they basically tried arguing that, I believe their argument was their fast food and not home delivery, but in the eyes of the trademark office, those are too close. And the whole point is to prevent consumers from being confused. This is just an example I really like because, no offense, I love when Mark Zuckerberg has to spend money. So Meta, there are actually at least 3 conflicting marks with Meta. And a lot of them are very unhappy that Facebook just went and started using this name. Meta company, Facebook actually approached them and said, can we buy your name? And they offered them a very small amount of money and the company said no, and they just went ahead and started using it anyway. So they are facing some serious trademark litigation right now.
It's even the idea they'll spend.
Yeah,
Facebook has so much money that
He'll-
they'll spend them in a fight.
he'll probably, yeah,
He'll lose, but public perception will be,
exactly.
it's not going to be well.
It really is, but they'll just run up the legal fees and Zuckerberg has a bigger pocket, so unfortunately. I'm hoping that they'll get a lot of money and these small companies will be able to take that and do something different, but it is unfortunate. One other thing I want to talk about is the difference between a state trademark or a state registration of your business name and a federal trademark. There is no correlation between the two. So you can register a business within a state, and if there's a federal trademark that exists, nothing is going to come up. You can register that name with your state. You can start operating, you can open up your business, and you can be operating for an undetermined amount of time, and then all of a sudden you can get hit with a cease and desist letter. I've seen it happen way too many times. So registering with the state is not enough to prevent infringement. You want to make sure that you're doing some searching, whether it's a basic Google search, having me do a trademark search, have someone do a trademark search, just to make sure that you're clear. Good examples are restaurants and dentist office. I actually have a client that's a dentist, and I recently did a trademark search for her because she's expanding into Massachusetts. And she registered the name with the state of Massachusetts, and I did a federal trademark search, and there is a company in North Carolina that has a federal trademark on that name. So it's a very good thing that she didn't end up choosing that name when she went into Massachusetts. This is a situation where an ounce of prevention is worth a pound of cure. So for startups, something that you want to be thinking about is trademarks and patents. This is a current client of mine. It's called Through. It's a drive-through rating app. If you have an iPhone, you could actually download it. It's a pretty cool feature. So we did a trademark search of Through. He decided he didn't want to file a federal trademark. He just wanted to start using it. Those are 2 different strategies I work through with clients. And so we did a trademark search to make sure that using that term wouldn't be stepping on anyone else's toes. That's the bigger problem. The last thing you want is a cease and desist letter after you've put all this time and effort into getting the business going. And the other important thing that we did is we filed a provisional patent application before he disclosed it. The United States, and actually we finally caught up with the rest of the world, is first to file system. So it's literally a race to the patent office now. And I've seen a lot of instances where even one day can make a difference. This is just a cool patent that I worked on that I liked. It's a card reader having a discriminator contact, which is a fancy way of saying it has an extra pin to tell if it's a chip card or not. Okay, so just briefly, the requirements for a patent are that it has to be new and useful. It can't be obvious in light of what's already out there. And it requires a drawing, a description, and a claim, which is basically just a picture, a description of the picture, and then saying, this is what I claim out of this picture. Some common mistakes that I see a lot are people disclosing their idea or their business before they have it protected. you're leaving ideas out on the table, that's the last thing you want to do. The other thing is choosing a name that's exactly descriptive of what you're doing. The trademark office will not let you do that. You don't want to not describe what you're doing, but it can't be exactly describing what you're doing. So if I read your name and I know exactly what you do, this is probably going to be a problem. If I kind of have to question it a little bit, can I use your name as an example? No?
Wait, of that thing that we're still working on that I have to say? Oh, yeah, sure, that one.
So, for example, Zach brings you. Zach brings you is suggestive. It suggests that Zach is going to help you with branding, but it's not really exactly descriptive of the services that he's providing. If it said Zach's branding services, that would be a problem. But where it's Zach brands you, it's a little different. It's kind of suggestive.
So leave it open ended.
Yes, and what they're trying to prevent is the natural flow of language. So if I could never say Zach's branding services, that would prevent the natural flow of English language.
So like a square card reader. If that was what it was called, that's describing exactly what it does, right?
But square in and of itself.
Right.
Right.
That's what I mean.
Yeah, yes, exactly. So they couldn't come up with square, thus square the card reader. That would not, exactly.
Yeah.
Or a square card reader, something like that, yes.
And that's because if they were to protect Square the card reader, no one else could have a card reader, correct?
Right, or the card reader, it would be,
You can't patent that, you can't trademark
Exactly.
something that would prohibit anyone else from even entering the market.
exactly,
Oh,
right. And the other mistake I see a lot is not doing a basic Google search.
That's what I
Start.
was thinking, like,
Yeah.
someone could just new client, whatever.
Google, always Google that.
We didn't Google when it happened, so. I mean, I don't care.
Okay. The other mistake I see is filing a really bad provisional. Sometimes doing nothing is better yourself. I don't think anyone does this anymore, but pulling copyrighted images and using them as your own. You can do that, but you need to give credit to the source. So I pulled that picture from that website and I said copyright IP Watchdog, quoted the website. You can do that, but you need to give credit for the source. A little more complicated than that. If you have any questions, I'd be happy to talk in detail, but that's kind of the gist of it. I'm going to use PopSocket just because it's one of my favorite examples. We have a client that's in this space. They're not PopSocket and they're not these. These are called Nuckies. Ever seen them?
Yeah.
So when you roll a product out, there are two things to think about. There are a lot of things to think about, but the two biggest ones are, am I going to step on anyone else's toes? Am I going to get caught in their web of protection? And how do I protect this myself? So we have a client that does knockoff devices, and they come to us and say, hey, we want to make a PopSocket. So we look up all of PopSocket's patents and we say, well, you can't have this, 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 or this, and then they come up with a design. My guess would be that these people did the same thing. Most PopSockets have that tapered design. So if you avoid that or you have a lot of patents, but if you avoid them, then you are good to go. The other thing you want to do is once you've figured out a design around, you want to protect that. So I would be willing to bet, it's not publicly available yet, but there's probably a pending patent on this. There's also trademarks to consider. Nuckies has a TM, and they use Snug Hug technology, which has a circle R. Circle R means that it is federally registered with the trademark office. TM means that it is either a pending application or someone that considers their state common law rights to give them trademark protection, but they are not federally registered.
So that's okay, they're okay because of all that. Like if they didn't do all that and they were just selling Nuckies, they'd be outside the space.
No, well, if they didn't do any searching, they could be. So if you just decided, hey, I want to make something like PopSocket, and you just went ahead and started designing, but doing research into what patents does PopSocket have, there's a good chance you're going to design something that's going to that they've already thought of. So a lot of people look at the PopSocket in a store and think, oh, well, I can avoid that, so that's it. I bet they have 10 other pending cases right now. I mean, they have I didn't know there were so many pop sockets in place.
Stephanie has a question. She mentions asking, can you just put a TM next to your logo without doing anything?
Yes, you can. And that establishes common law rights, and that puts others on notice that you intend to use that as a trademark, sorry, not a federal trademark, but that you intend to use that as a trademark and or are using it.
But does your state have that certain law in place in order to protect it or not?
This is something that would vary state to state, but most states have common law trademark rights
Yeah.
that exist when you use them,
Okay.
and they are regional.
So like when I was in California doing that,
Yes, for California. So let's say you used it in California for 5 years, and then you expanded and used it in Texas for 5 years. You'd be covered in California those first 5 years, and both California and Texas those 10 years. If you had a federal trademark, you'd be covered everywhere all the time. And a federal trademark is not that much more expensive than a state trademark. So there are defenses to trademark infringement. One is, and copyright infringement also, but trademark infringement, one defense is fair use. One fair use exception is a parody defense. And the parody defense is so strange to me because it has to call the actual product to mind. So you have to know that they're talking about in this example, they're clearly talking about Starbucks, but you have to also clearly say that you're not talking about Starbucks. So it has to give the impression that yes, you're using the original source or the original product, but that you are definitely not it. So there's no way that Starbucks would ever want to be called the dumb Starbucks. So no consumer is ever going to be confused about that. That's basically the reasoning behind it.
Wait a minute.
But
This was actually on a TV show.
But aren't they using the logo?
They are, but it is so clearly not Starbucks.
Wow.
One of my favorite shows.
Wait, so why isn't somebody doing
I'll
stupid
explain
things?
it.
They could. I mean, they would not last because Zuckerberg's,
Not
Shoot 'em
safe.
down.
Yeah, right, well, no, but if it's fair use, it's a parody.
Yeah.
Meaning what, that company right there, that those people lined up on it, they're not selling coffee?
They are,
No, they're selling.
Yeah, they're selling
They're not
coffee,
selling
they're
Starbucks.
not Starbucks.
exactly.
They're selling
Dumb
like
stuff.
knockoff Starbucks coffee,
Exactly.
basically what they're saying, so why couldn't you have stupid Facebook and still have it be a social media platform?
You could, but my guess is that Zuckerberg would make your life so difficult.
But so many people don't like him for that.
But let's all team up.
I
and-
know. Yeah, that's what we are doing, that's why I'm asking you.
It's the infrastructure.
Because.
It wouldn't be able to.
And so we could, but it wouldn't be able to competitive at the level that we're impact.
So there's also a fair use defense in copyrights. This was a big case that came out this year, and software engineers and patent attorneys were freaking out about it because I don't want to go too technical, but basically Java had some APIs that Google was using, and they were considered fair use because what they determined was that if Oracle or Java was able to say that these APIs were their APIs, which is basically like how, I don't know if anyone knows much about this, but it's how most computers communicate with each other, or applications communicate with each other now. It would have had such a negative impact on the economy in general because people wouldn't be able to do things. So there are 4 factors that come in for fair use. Purpose and character of the work. Did you directly copy it, or did you transform it in some way or make it your own? Nature of the copyrighted work. Is it factual or fiction? Factual works are easier, or they give more leeway in terms of copying because it's facts that are out there versus fictional. One of my favorite examples is Harry Potter. J.K. Rowling, you don't do anything Harry Potter, not even as a joke, she will, because it's fictional, it's very hard to copy that. Amount used and then the effect on the market. And I'm sure Some of you may remember the 2015, I was gonna play it, but I'm not sure if it'll come through. But the Blurred Lines song, I mean, if you play one and then the other, it sounds almost identical. And that was worth 5.3 million in royalties, and that was definitely not fair use.
So you have no ice.
Yes. Yep, there's a few. So just to kind of recap on some of the services that the firm provides, we do trademark clearance search and filing of trademarks if you decide to go forward. I'm also very excited to announce that we are able to handle branding strategy. We have an in-house branding strategist. And the way that we are able to do that is the attorney-client privilege doesn't extend. However, we have a non-disclosure agreement in place. So basically, anything that we share with the IP branding strategist still remains confidential. So we are very excited to be able to offer that service. Patentability searching, product clearance search, and analysis. So just in conclusion, I always like to remind everyone that although I'm based out in New Hampshire, I can serve anyone in the United States. It's one of the benefits to going through all the extra hoops to becoming a patent attorney. And also I do provide a free 15-minute consultation if anyone is interested. One of my favorite Thomas Edison quotes: I make more mistakes than anyone else I know, and sooner or later I patent most of them. Awesome. You have any questions? You guys are great.
I was supposed to hold them to the end, huh?
No, that's fine. That was great. That was perfect. Sometimes it's better like when I'm talking. So,
So can I patent my name, Liz?
what's the full name?
Liz, that's it.
It would depend if there's anyone else in that class already or with that name that would require a search. But yes, that's something that.
Would you be patenting what? Your amazingness?
No, I'm actually just using it for other things.
You mean trademark it or patent?
Actually, I mean trademark.
Did you say that?
Yeah, I did say that, right.
Okay, that's
I
right.
did say that.
Here's a question that I have about that. Now, there is a video game franchise called Blitz. And I don't know if they would own something that if it's sports related or fitness related, would that be too close?
It would depend on what classes they filed their name in. So if it's a sports related video game, probably not, right? Because again, the concern is our consumers going to be confused. So they're probably not going to be confused as a video game associated with sporting equipment.
Sometimes those are blurred lines.
So is that kind of?
It's
Is
not
that that?
It's trademark.
No, there's one.
It's, I don't know if there's more than one, but there's one enforcement.
Yeah.
But not, like, unless they trademark that, they don't have to hold on that, right? I mean, right. So it's a good point, we use your name.
Yes, yes. And you can trademark your name. That's possible. But in trademarks, again, it all comes down to the classes you file, which makes sense. You don't want someone to be able to get one name in everything. You want it to be limited to exactly what they're using it in. Large companies like Publix, it's a grocery store down south, they have 150 trademarks. Crocs has over 30. They actually sued Walmart, Hobby Lobby, and a bunch of companies earlier this year for millions of dollars because they had a trademark on the design of their shoe. And it had the trapezoidal holes in the top front and the holes on the top. And so anyone that had that trapezoidal front and holes on the top, so I don't know if you noticed, but there were no Crocs anywhere for a while because all those companies had to redesign their Crocs. So that's a really smart way to protect something. You can't get a patent on a Croc. There's nothing new or useful or obvious about it, but the design itself, and as long as you're using a trademark, you still have rights to it. So it's actually very smart.
You get a patent on the material it's used, like only Crocs made out of silicone, not some cork or something.
It's possible. You can. I have a case that just recently issued. I'm trying to think if I can disclose it or not, where they figured out how to clad two different materials together for diamond drill bits where this is not my strength, there were niobium and tantalum. And if you made the entire thing out of one material, it was much more expensive. But if you put that material on the inside and another material on the outside, you still have the benefits of that expensive material touching the drill bit, the non-expensive. So you could make a much less expensive device, so that we did get a patent on that, because there was no one else out there that could put those two materials together in that order for that purpose. And it's known to, you know, put those two materials together or something like that, so. Actually, just yesterday, Moderna was actually lost because there's a separate appeal board for patents. If you try to get a patent and it doesn't go through, you can appeal to the patent and trial appeal board. And Moderna tried to get 2 patents for their COVID-related mRNA vaccines, and the PTAB said that they were not patentable. And there's another company, Arbutus, they actually counterclaimed and said that you're actually infringing on our patents. So Moderna, this was just released yesterday, may be facing $18 billion in legal fees for infringing someone else's patents. So
The Apple and Samsung have.
Such
that
fast-
they want to-
they're
Is it still going?
always.
You still going?
No, I think
I don't
it's
know if it
settled.
will ever end.
I'm pretty sure it's settled, but I think it might look different now. It's a different version.
Phones are still, they're going to use some things.
And then Samsung is making their screens too, so I know that we've got a real complicated.
Yes.
Got a real
Windows
complicated.
is different.
Oh, yeah.
There's probably some cross licensing would be my guess. And that's a lot of reasons why companies get patents. So that if they run up against someone else that has a patent, then they can come to them and say, hey, I see you have this patent. I have this patent. Would you like to cross license the technology so it doesn't cost you anything and it doesn't cost me anything to use yours? That's actually part of how Amazon has grown so large. They don't ever sue anyone, they wait till someone sues them.
You guys have any questions on the virtual land? No? Okay.
No, great job. Thanks for having us.
See you guys. Thanks, guys.
Bye, everybody.